Hello students, let us discuss about the structure of Indian Companies Act. Let us discuss about the differences between Companies Act 1956 and 2013, and also let us have a discussion on incorporation, steps involved in incorporating a company under Companies Act 2013. First, let us have an understanding about the structure of Indian Companies Act. The Government of India assigned 12 members to frame the regulations of company law in 1950. This resulted in the development of Companies Act 1956. Later on, Indian business environment was undergoing major changes which gave rise for the need to have an amendment of Companies Act 1956. On 29th August 2013, President approved the enactment of Companies Act 2013. This act is framed by considering the new economic conditions. Companies Act 2013 encourage corporate democracy. The structure of Companies Act 2013 compared to Companies Act 1956 is clearly explained. Structure of Indian Companies Act, Companies Act 1956, Companies Act 2013. If you take Companies Act 1956, there are only 13 parts, 700 sections, 15 schedules. In Companies Act 2013, there are 29 chapters, 470 sections, 7 schedules. As discussed, the Companies Act 1956 combination shows only 13 parts, 700 sections and 15 schedules, whereas the Amendment Act, Companies Act 2013, is designed with more brief description and structure, which consists of 29 chapters, 470 sections and 7 schedules. The Companies Act 2013 came into action on 1st April 2014. The structure of this Amendment Act is designed in compliance with the international requirements. It applies to low organizational barriers, ensuring to carry out business easily in India. It functions to protect the interest of shareholders, to attract more investors. The Companies Act 2013 is applicable to every company registered under this Act or any preceding company law or any company registered under any special act for time being in force. Now let us have a discussion on the differences between Companies Act 1956 and 2013. We will be taking some 10 points and comparing the Companies Act 1956 with the Companies Act 2013. First, let us take the point structure of financial statements. The structure of financial statements are mentioned in Schedule 6 of Companies Act 1956. I repeat, the structure of financial statements are mentioned in the Schedule 6 of Companies Act 1956, whereas in Companies Act 2013, the revised structure of financial statements are mentioned in Schedule 3. They are mentioned in Schedule 3. Now, let us have the differences of Companies Act 56 and 2013 based on the financial year. The financial year ending date of the company should be decided by the company itself in Company Act 1956. When coming to the Companies Act 2013, companies must close their financial year on 31st March every year. Next point, sections and schedules. The Companies Act 1956 consists of 658 sections and 15 schedules. The Companies Act 2013 consists of 29 chapters, 470 sections and 7 schedules. Coming to the shareholders, As per 1956 Act, the maximum number of shareholders in a private company were allowed to be 50, excluding the past and present employees. As per 2013 Act, the maximum number of shareholders in a private company are 200, excluding the past and present employees. One-person company. The one-person company policy did not exist in the Companies Act 1956. The one-person company policy exists in the Companies Act 2013. Minimum subscription. As the Section 69 of 1956 Act, the minimum subscription of a company was based on shares only. As per 39 of 2013 Act, companies should subscribe and pay the minimum subscription mentioned in the prospectus. Securities Premium Reserve. In Companies Act 1956, employment of Securities Premium Reserve was stated under Section 77A and 78. In Companies Act 2013, employment of Securities Premium Reserve was stated in Section 52 of Subpara 2. Distribution of shares. Section 79 of 1956 Act allowed shares to be distributed at a discount. Section 53 of 2000 Act does not allow the distribution of shares at a discount. Section 54 allows the issue of employee stock ownership plan at a discount to the employees. Interest on calls in arrears. Interest rate chargeable on calls in arrears is 10%. Interest rate chargeable on calls in arrears is only 5% in Companies Act 2013. Interest on calls in advance. Interest rate is 12% on calls in advance in Companies Act 1956, whereas interest rate is 6% on calls in advance in the Companies Act 2013. Now, let us discuss about incorporation. Various steps involved in incorporating a company under Companies Act 2013. Incorporation. It refers to the formation of a legal and authorized corporation or company. The incorporated company is legally registered as per the Indian Companies Act 2013 or any latest amendments. Process of incorporation of a company. Registration and incorporation of a company is the second stage of formation of a company. After registration, the company, after getting certificate of incorporation, a company comes into existence. The 4 steps involved in the process of registration and incorporation of a company are as follows. First step is preliminary steps. Second, application for registration of documents. Third, examination and registration of documents by the registrar. Fourth, issue of certification of incorporation and CIN. CIN means Certificate of Incorporation. Preliminary steps. Deciding the type of company. The promoter has to decide which type of company he wants to register as per the Companies Act 2013. Both public company and private company can be registered. Even one-person company can be registered, but as a private company only. Deciding the location of registered office. The promoter has to decide the location of registered office of the company. Acquiring a DIN from central government. Acquiring director's identification number is compulsory for the person who wants to be a director of a company. It is unique and permanent number given by the central government in response to the application submitted by the prospective directors. Acquiring digital signature. Digital signature is an electronic signature made through electronic means. In order to get a company registered, the companies are required to e-file documents with digital signature, as manually signing e-file documents is not possible. Selecting and reserving company name. A proper name has to be selected by the promoter of his intended company and get the name reserved. Drafting memorandum. In Schedule 1 of the Companies Act 2013, Table A, B, C, D and E comprises formats of memorandum for different types of companies. By taking into consideration these tables, promoter of the company along with solicitor, company secretary and so on draft the memorandum of the company. Drafting articles, the articles of association, is another essential document of the company which includes regulations for internal management of a company. The articles may include prescribed matters and also additional matters. Inspecting the drafts. The memorandum and articles drafted by the promoter must be inspected by the registrar to prevent mistakes and delays in the registration of the proposed company. Printing of the memorandum and articles. The memorandum and articles must be printed as per the specifications given in the Act. Stamping of the documents. Memorandum and articles must be stamped as per the stamps laws applicable to the respective documents. Dating of the documents. Date should be specified on memorandum and articles. After the stamping date, any date may be chosen for dating the documents. Obtaining signature and subscriber. There should be a minimum 7 subscribers in the public company, 2 subscribers in the private company, and 1 subscriber in one-person company. Getting consent of the nominee in the case of an one-person company. In order to include the name of nominee of the subscriber in the memorandum in case of one-person company, prior consent has to be acquired from the nominee is written in form number INC 3. Acquiring declaration as to compliance with the legal requirement. A declaration in form number INC 8 should be acquired by the promoter of the company. Getting affidavit from subscribers and persons named as first directors. A promoter must also acquire an affidavit in form number INC 9 from every subscriber to the memorandum and from individuals who are named as the first directors in the articles of association. Acquiring particulars of subscribers, directors, etc. The particulars of the following people must be acquired by the promoters: particulars of every subscriber to the memorandum, particulars of individuals stated as first directors, particulars of individuals stated in the articles as first directors of the company in other firms or corporate bodies. Get consent of the first director. The promoter must get the written consent of the individual who wants to act as first directors of the company. Getting approval of the sectoral regulators. At times, a company aims to possess objects which requires registration or approval of sectoral regulators like RBI and SEBI. In such situation, promoter has to get approval from the sectoral regulators. Drafting contracts. If the promoter intends to include other contracts in the term of incorporation of the company, then he will draft such contracts. These contracts contain all the preliminary contracts. Coming to the second step, which is called application for registration of documents. The following are the documents and information which are to be enclosed with the application. Notice of address for communication. The company applying for registration must enclose a document comprising the notice of the address for communication with the registrar. Memorandum of the company. The memorandum of association of the company with signatures of all subscribers must be submitted to the registrar. Approval from sectoral regulators. At times, company aims to pursue objects which require approval from sectoral regulators like RBI and SEBI. Articles of the company. The articles of association of the company where the signature of all the subscribers to the memorandum must be submitted to the registrar. Declaration as to compliance with rules and regulations of the Act. A declaration form number INC 8 to be submitted to the registrar. In the declaration, the proposed company declare that it is complied with all the rules and regulations of the Company Act 2013. Affidavit from subscribers and individuals named as first directors. A proposed company must submit an affidavit in form of INC 9 to the registrar. In affidavit, it is declared that no offence is conducted in relation to promotion, formation, and management of the company. He is not involved in any fraud or misrepresentation. The documents submitted to the registrar are true and complete to the best of the knowledge and belief. Particulars of all subscribers. The details of all subscribers to the memorandum of association of the company must be submitted to the registrar. Particulars of first directors. In the form number DIR 12, the intended company must submit to the registrar the details of individuals named as first directors. which are mentioned in the articles of association of the company. Particulars of interest of directors. The intended company must submit the details of the interested individuals stated in the articles as the first directors of the firm in other company or corporate bodies. Consent to work as directors. A copy of the consent obtained from the people who agreed to work as directors of the company must be submitted to the registrar. Copy of the confirmation letter. A proposed company need to submit a copy of the confirmation letter received from the registrar confirming reservation of company name. Power of attorney executed by the subscriber. At times, if a subscriber wants any other person to sign memorandum of association or articles of association on behalf of him, he needs to execute power of attorney. Power of attorney to make corrections. In order to allow any person to make corrections in the documents submitted to the register, all subscribers execute power of attorney. A copy of concerning this must be submitted to the registrar at the time of registration of a company. Payment of fees. The company should pay specified registration fees to the registrar. Examination and registration of documents by the registrar is the third step. The registrar must examine the documents after obtaining the application and the delivery of documents for incorporation from the company. If all the documents filed by the company are in sequence, then the registrar registers all such documents and information in the register of companies. If registrar finds any minor mistake in a document, then he may ask the authorized person to correct such mistakes. If major mistakes are found, then all the documents which were submitted are sent back to the company for corrections. A registrar may refuse to register a company if, as per the law, registration of such company is lawful. If registrar is refusing to register a company even though registration of such company is lawful, then in this situation registrar may be forced to register. Fourth step, issue certificate of incorporation and a CIN, certificate of incorporation. After the registration of all documents and information, a certificate of incorporation is issued in the form number INC2 by the registrar, stating that the intended company is incorporated under the Companies Act 2013. An incorporated company gets corporate identity number from the registrar on the date specified in the certificate of incorporation. CIN gives distinct identity to the company and is included in the certificate of incorporation. Certificate of incorporation is a conclusive evidence of date of incorporation. With this certificate, company comes into existence as a separate legal entity. It is an evidence of registration and existence of a company as a legal entity. The date which is given in the certificate of incorporation is regarded as the date of incorporation of the company, irrespective of whether it is correct or wrong, and from the date of company functions as a corporate with the name mentioned in the Memorandum of Association. Usually, a company comes into existence from the date of incorporation mentioned in the certificate of incorporation. If such date is not mentioned in the certificate, then the date on which certificate is issued is considered as date of incorporation, irrespective of whether it is correct or wrong. After the issue of certificate of incorporation, the validity of registration cannot be challenged or questioned. Certificate of incorporation cannot be cancelled once they are issued. Even though the objects are legal, the only remedy available is winding up of a company by tribunal. Thank you.